Good afternoon, everybody. Welcome to the Georgetown University Law Center. My name is Jordan Usdan, and I'm the president of the Law School Democrats. And on behalf of the Law Democrats, the Alliance for Justice, and the Committee for Justice, I would like to welcome you to the great debate, John Roberts and the future of the Supreme Court. If confirmed, John Roberts will become the 17th Chief Justice of the United States, and only the 10th since the Georgetown University Law Center was founded in 1890. While we are familiar with the legacies of the Warren Court, the Burger Court, and the Rehnquist Court, if confirmed, how will the Roberts Court make its mark on history? Our two debaters will have their say in just a few minutes. For now, I would like to introduce Nan Aaron. A leading voice in public interest law for over 30 years, Nan Aaron is president of the Alliance for Justice, a national association of public interest and civil rights organizations. Nan, who founded the Alliance in 1979, guides the organization in its mission to advance the cause of justice for all Americans, strengthen the public interest community's influence on national policy, and foster the next generation of public interest advocates. In 1985, Nan founded the Alliance's Judicial Selection Project, now the country's premier voice for a fair and independent judiciary and a major player in the often controversial judicial nominations process. Nan has taught here at Georgetown, across town at the George Washington University Law School, and currently serves on the Dean's Advisory Council at American University's Washington College of Law. Nan was selected by Nonprofit Times for the 2005 Power and Influence Top 50 list. She has also served as executive producer for several award-winning films on immigration, courageous justices, and gun violence. Ladies and gentlemen, help me in welcoming Nan Aaron.
Thank you for your very kind words, Jordan. And thanks to our event hosts, Georgetown University Law Center and Georgetown Law Democrats. I'm so happy to kick off the Alliance for Justice's Student Action Campaign here at the Georgetown University Law Center. Student Action Campaign, which is sponsored by the Alliance for Justice, is designed to reach out to law students and engage them in a national conversation about some of the most pressing issues affecting our country today. Past issues we've dealt with concern housing and homelessness, immigration, the death penalty, gun violence, and post-9/11 civil liberties. This year's campaign will work with students and activists around the country during the course of the school year to organize events on campuses and in communities to focus attention on the importance of the Supreme Court and our federal judiciary. The timing for this event couldn't be better. This year's campaign begins as the United States considers the nomination of Judge John Roberts to be 17th Chief Justice in American history. As you probably know, tomorrow the Senate Judiciary Committee, those 18 members, will vote on John Roberts' confirmation. Next week, the full Senate will be considering his nomination. It's really a historic moment in our nation's history because Supreme Court nominations don't come about every day. In fact, this is the first one in 11 years. Now, we have not just one, but two nominations, Roberts, and who knows who the second one will be. In fact, just this morning, President Bush met with Senate leaders to talk about replacing the person for the Sandra Day O'Connor seat. And commentators of all political stripes agree that with two new justices, that the court's often precarious balance could shift, perhaps dramatically so, given retiring Justice Sandra Day O'Connor's often pivotal vote in 5-4 decisions. This historic moment has captured the attention of law students around the country. In fact, students on nearly 100 campuses are tuning in to today's event. We're saddened that those students that attend law schools in the Gulf area are unable to participate because of Katrina, but you'll be pleased to know that we are producing some videos and DVDs that will provide you with a glimpse of today's program. And in addition to today's satellite broadcast, the event will be webcast live and available as a podcast, a downloadable file for MP3 players. And if you are watching remotely, you may email your questions to our debaters anytime during this broadcast to Student Action Campaign at AFJ, standing for AllianceForJustice.org. That's Student Action Campaign at AFJ.org. Joining us today to speak to the question of John Roberts' nomination and the future of the Supreme Court are two very distinguished voices from the academic and legal communities. First, we have Ronald Cass. Mr. Cass is co-chairman of Committee for Justice. He is also president of Cass Associates, which specializes in strategic advising for companies and law firms on matters concerning international trade, intellectual property, and antitrust law. Mr. Cass has a very distinguished career. He served for 14 years as dean of the Boston University School of Law. He's had a varied and prestigious career in the arbitration of international trade and consults for governmental agencies and private firms. Early in his career, Mr. Cass was law clerk to the Honorable Colin Seitz, Chief Judge of the U.S. Court of Appeals for the Third Circuit. And we appreciate the Committee for Justice for co-sponsoring this event. Also with us is Charles Ogletree. Mr. Ogletree, the Harvard Law School Jesse Clemenko Professor of Law and Vice Dean for Clinical Programs, is a prominent legal theorist who has made an international reputation by taking a hard look at complex issues of law and working to secure the rights guaranteed by the Constitution for everyone equally under the law. Professor Ogletree has served as faculty director, associate dean, and vice dean of the Harvard Law School Clinical Program. He has examined legal issues not only in the classroom, on the internet, and in the pages of prestigious law journals, but also as a public defender in the courtroom, in public TV, and numerous books and articles. Professor Ogletree also served as legal counsel to Professor Anita Hill during the 1991 Senate confirmation hearings for Justice Clarence Thomas. And last but not least is our debate moderator, who is Emily Bazelon, a senior editor at Slate and a frequent commentator on judicial nominations. Before joining Slate, Emily Bazelon worked as an editor and writer at Legal Affairs magazine and as a law clerk with the United States Court of Appeals for the Fourth Circuit. Ms. Bazelon's work has appeared in the New York Times Magazine, the New York Times Book Review, Mother Jones, the Washington Post, the Los Angeles Times, and the Boston Globe. Thank you all for joining me today and us, and we look forward to a very exciting debate.
Thanks very much, Nan. It's a great pleasure to be here for this event. It's particularly a great pleasure because my family has some long-standing ties with Georgetown Law School through different members of the faculty, including Peter Edelman and Judith Areen. And my sister Dana is now a student here, and I feel like I'm actually here on her coattails because I originally met Nan when Dana was working at the Alliance for Justice before law school. And I'm also particularly pleased to be here because I think the framing of this debate about the confirmation of Judge Roberts to the Supreme Court is a question that in some forums has been sort of skipped over. Some senators in particular seem to be thinking as if Judge Roberts, because he might be seen to be a sort of one-to-one trade with Chief Justice Rehnquist in terms of his likely voting patterns, that his sort of confirmation should be assured and may not, particularly matter for the future shape of the court. And this seems to me to be a strange assumption because of the obvious reason that Judge Roberts will have a vote, one hopes, if he is confirmed, for a long time on the court, and also because of all the powers of the Chief Justice and the administrative as well as judicial functions of the court. And the third reason is because the Supreme Court is a small group, and like any small group, it's affected by its internal group dynamics. And so any change on the court in any of its personnel can reverberate in ways that we really can't predict. And so for all of those reasons, this question about whether Judge Roberts should be confirmed is, of course, an extremely salient one, particularly right now. And I'm very honored to be here with our distinguished debaters, and Mr. Cass will begin.
Thank you very much. I hope my mother caught Nan's introduction on her iPod. I very much appreciate that, Nan. The great American philosopher Yogi Berra once said, "It's very difficult to make predictions, especially about the future." Yogi was obviously right. Making predictions about the future is a risky business. There are times when you have to do that, but one should do that with a certain amount of modesty, because most of the time the predictions we make turn out to be wrong. The founders of our nation made a prediction many years ago that we could design a framework for government that would promote liberty and prosperity for the American people for generations to come. They set up a system that depended on certain structural features. The first and most important one was divided government. Our founders thought it was very important that most decisions on most issues be made by the states. On a few issues, such as the national defense or the regulation of interstate commerce, the founders thought it was important to have a national government that could make decisions in areas where the states really could not make the decisions effectively on their own. Another structural feature of our government was that of divided power within government. The founders set up a system where we had political branches of government, the President and the Congress, responsible for making policy decisions and putting them into effect. The third branch of government, the courts, was designed not to make policy, not to put policy into effect, but to decide cases, to interpret and apply the law. Our founders were very clear that in the course of deciding what the law was, the courts would have to at times tell the other branches that they may have overstepped their bounds. When they do that, the other branches are always unhappy, but it's part of the job of deciding cases under the rule of law. The appointment of officers of the United States, including judges, was vested in the President. And when the founders created the system we have, they were very clear that this was not a shared power. The President is responsible for appointing judges. The Senate has a minor role, the advise and consent role. It's a role that consists of checking to make sure the President has appointed people of competence and propriety, and it goes no further than that. Alexander Hamilton wrote 3 lengthy essays on this in the Federalist Papers. He said there was some very reasonable complaint about having the Senate play a role at all, but given the modesty of the Senate's role, he thought it was appropriate to allow it to participate to a limited extent in this process. For the first 200 years of our nation's history, it was pretty well understood how this worked. We had a couple of periods when political fighting erupted just before and just after the Civil War, and the appointments process got caught up in that. But by and large, it was understood that the President enjoyed a great deal of deference from the legislature in appointments. For the first 2/3 of the 20th century, only one Supreme Court appointment was rejected by the United States Senate. Recently, groups that are deeply invested in using courts to promote sorts of change in the society that they want and have not been able to achieve through the legislative and electoral processes, have become deeply involved in fighting over the selection and confirmation of judges. And over the last 2 decades, we have seen the process of confirmation become a much more contentious and much more visible process than it had been before that. Some of the groups that are invested in this process have a conception of the law that asks that we try to select judges who will freeze the law in place, keep it from moving, make sure that the precedents don't change because we like the precedents the way they are now. That's a dangerous game to play. It's dangerous in part because if you really try to freeze precedent, you will lock the law into some patterns that you will come to regret. Certainly, anyone who was trying to lock the law into place in the 1940s and early 50s would have left us with the precedent of Plessy against Ferguson, which was overruled in the Brown case. Anyone who was trying to freeze the law in the 1960s would have done so before the decision in Roe against Wade. Whether you like or dislike the changes in the law, it's very difficult to predict how you will like what happens in the future as these changes occur. It's also difficult when judges are appointed to predict what the big cases are they will decide. The court that decided Roe against Wade included a judge appointed in the 1930s, 35 years before Roe against Wade. No one, I assure you, engaged in that appointment process or confirmation process was thinking about abortion rights when Justice Douglas was confirmed for the court. There are predictions that are being made today on Judge Roberts. The National Organization of Women, the Alliance for Justice, a number of groups have weighed in against Judge Roberts, and many of them have said that if he's confirmed, he will turn the clock back 40 years. That's exactly what was being said by almost the identical set of groups when Justice Stevens was nominated, when Justice Souter was nominated, when Justice Kennedy was nominated. The testimony from now, when Justice Stevens was nominated, said that he lacks the ability to have an impartial review of cases involving women's rights. When Judge Kennedy was nominated, now said that if he's confirmed, women will have no choice but to resort to back alley abortions. There will be Saturday night massacres in the hospitals of this country. And when Judge Souter was nominated for the court, now said that David Souter will tip the court dangerously out of balance. I tremble for the country if you confirm David Souter, but most of all, I tremble for the women of America. Clearly, the predictions of how these judges would vote were well off the mark. When President Clinton replaced Byron White, who was one of the dissenters in Roe, with Ruth Ginsburg, he wasn't looking at keeping a balance on the court. He wasn't looking at freezing the law in place. He was saying, I want to find someone smart, able, competent, who will do what I think I would like on the court. And he picked someone who was confirmed 96-3. I think that's the sort of precedent we should look at as we make nominations for the court, and it's what I expect President Bush to do with his nominations. Whatever happens in the process, it's laudable that we have engaged the attention of so many students in so many schools across the country. When I was a law school dean and a professor of constitutional law at roughly the same time as Marbury versus Madison was decided, I was always looking to encourage students to get involved in exactly these sorts of issues, and I welcome all the students across the country who are tuning in. Thank you.
Thank you, Dean Cass. I'm so pleased to be here at Georgetown Law Center to participate in this discussion. It's really not a debate, but we do have differences, and I think they will be laid out in the short time that I have. First, I want to congratulate the students around the country for listening to this discussion and making an evaluation of the most important time in your lifetime. It is amazing that you, unlike many of us, will be able to see in the course of your life a completely different Supreme Court that will change dramatically, not just over the next few weeks, but over the next few years. It's not inconceivable that the court's composition could change by 3, 4, or 5 justices, either through President Bush's second term or shortly thereafter. And so it's going to be a different court, one that you never imagined. No one can predict where it will go or what will be the consequences. There are some basic premises on which I disagree with my dear friend, Dean Cass. First, he says that Senate plays a minor role in the confirmation of a Supreme Court justice. It couldn't be further from the truth. Article 1, Section 2 makes clear that the president nominates, not appoints, nominates justices, but it requires the advice and consent of the Senate. Indeed, the president cannot put someone on the court other than a recess appointment without the approval and express approval of the Senate. And every senator has to take his or her responsibility seriously to confirm. The second point that's important to note is this: I want to spend some time actually talking about John Roberts and giving it a context. Why is this nomination so important? Why are we spending so much time talking about one appointment to the Supreme Court? Because we know history. We know the history of this court. This is the court appearing to be applying a constitution that said black people had no rights, which whites were bound to respect. This is a court that tolerated slavery and treated African Americans as 3/5 of a person. This is a court that endorsed and indeed celebrated by a 7-1 decision in 1896 the awful doctrine of Jim Crow laws and Plessy versus Ferguson. So the court matters, the Constitution matters, justices matter. That turned around dramatically in the 1950s because the court paid attention to a different America, an America where women and men could vote, where people without regard to where they lived or their religion or their income had a right to equally participate in our democracy. It is the most essential aspect of our democracy that it's a place where people can participate and make a difference. It is the court and not the people that decided Brown versus Board of Education nearly 50 years ago, a little more than 50 years ago, and ended as a matter of law the awful doctrine of separate but equal. It was the court that recognized that women were having backroom abortions, losing their lives, and recognized a fundamental right to privacy, endorsed not by a liberal branch of the Supreme Court, by liberals and conservatives who finally understood that the Constitution had to evolve to meet the evolving standards in the 21st century. It was the Supreme Court that decided that suspects who find themselves in custody and interrogated have a right to be given their rights under Miranda versus Arizona. And those are just fundamental doctrines that have made such a big difference. And when we think about a change in the composition of the Supreme Court, each and every doctrine is subject to reconsideration if 5 justices, just 5, decide it's time to go in another direction. And indeed, if you look particularly of this court, which is a cohesive court of the last 10 years, they've also had a very remarkable number of decisions decided by votes of 5-4. And the key person in that vote often was Justice Sandra Day O'Connor, who announced her intention to retire at the end of last term. What do we say about John Roberts and his impact on the Supreme Court? It will be fundamental, it will be significant, it will be substantial, and it will be not for 20 or 30 years, perhaps 40 years. Given the medical care that we have now and his good health, he could serve well into the twilight of all of our lives, certainly, but the lives of you and your children and perhaps even your grandchildren. So it is a lot that's at stake. What do we know about him? He's brilliant, he's prolific, he's worked exceedingly hard to make his views clear. And if that were the only qualification, he would be easily confirmed as a member of the U.S. Supreme Court. Robert Bork was brilliant and prolific, but people thought that he had a perspective, had an ideology, had an attitude about law that was unhealthy in the 20th century, and that's why he was rejected. And indeed, it's not about John Roberts' base qualifications, because there are thousands of lawyers, members of the legal profession in this country, who are qualified to serve on the Supreme Court, but that's not enough. Being qualified is only the threshold to be considered, and then each and every member of the Senate has to then determine whether or not you are appropriate for the task. John Roberts is qualified in another significant way. He is one of 5 justices who were educated at Harvard Law School, where I attended and where I now teach. That certainly makes him qualified for the Supreme Court. But that's not enough. That's, again, a threshold question. Then you have to examine what we know about John Roberts. First, we know he's a prolific writer. We know that he's been actively involved in every Republican administration in one respect or another since he graduated from law school the year after I did and worked in the Reagan administration. We know that he has been acerbic on occasion and certainly skeptical, calling Roe versus Wade the so-called right to privacy, talking about affirmative action and being hostile in his written memoranda and his attitude toward it. And that gets to the ultimate question. What does all that mean? Dean Cass is right. We don't know how he'll vote tomorrow or next week or next year, but we do have an idea. And the one thing about law students and about lawyers, I think you would not be very successful in your law class if a professor posed a question and asked for an answer, and you said, I don't have a thought. I don't have any idea. You always have thoughts. And something about your experience, your life, your friendships, all influence how you think. We know John Roberts' experiences, his lifestyle. We know what he's done. He's well regarded on both sides of the aisle, but in terms of his ideology, it's clear that he is conservative. He's been consistently conservative, and there's never been any doubt about that from the time that he was a young college student and more recently a law student and more recently a lawyer. The Senate's role. We all know that Senator Harry Reid last year in December on an interview talked about ideal Supreme Court Chief Justices. And he indicated his criticism of Clarence Thomas, but he also said that he wasn't sure, and that's what he said in December, that he would oppose Justice Antonin Scalia from being promoted because Scalia was a very bright man. That was his view. Well, he's had a chance to evaluate John Roberts, to look him in the eye for the last few days. And what he has decided is to vote against John Roberts for two reasons. One is that material that was relevant to making a determination was not turned over, and two, his answers were evasive, incomplete, and disingenuous. The Senate has a right to have a reason to approve a candidate, not a reason to disapprove a candidate. And if you don't have a abiding conviction that the person you're going to confirm is someone who will uphold the Constitution as we know it, the Constitution that gives women suffrage when they didn't have it before, the Constitution that gives minorities basic rights like education and voting that we didn't have before, the basic rights to travel, the rights of federalism, the rights of the state against individuals and individuals to protect themselves. If we don't see that those rights are protected, then there's a serious concern. I suspect, without doubt, that John Roberts will be confirmed as the Chief Justice, but I also suspect that many senators will do their constitutional duty and oppose him because they don't think that he's the right man at the right time for the right job.
Thank you so much, Mr. Cass and Mr. Ogletree. Now we're going to take a couple of questions from the audience. Yes, go ahead.
Hi. Well, this is a case of Judge Roberts that hasn't been discussed much, or at least I haven't heard discussed.
That's from
It's what they're now calling. Hi, how are you?
We're fine and welcome up
Good,
here.
thank you very much. There's a case that they're referring to as the hapless toad case, in which Judge Roberts found that certain parts of the Endangered Species Act would be found unconstitutional due to the fact that it doesn't regulate interstate commerce. What is your feeling about whether such a strict reading of the Commerce Clause could have far-reaching impact, especially if it's shared by other members of the court?
Well, let me start out. You're talking about the Rancho Viejo case.
Yes.
And before I answer the question about the constitutional interpretation, that actually isn't what Judge Roberts said. What Judge Roberts said is that he wanted the court to reconsider a panel decision in the case with all the members of the court looking at the decision, because he thought the decision of the panel, the three judges who decided the case, might conflict with other decisions of the court. There was an opinion written by one judge who said he thought that the statute probably contravened the Interstate Commerce Clause as it was applied in that case, that wasn't Judge Roberts, that was Judge Sentel. There are some serious questions about the scope of the Interstate Commerce Clause. They are seriously debated by people of every different political ideology. And I think those are important questions to have on the table for the Supreme Court. But nothing that Judge Roberts said indicates an intention to cut back. I'd be happy if he did, but he hasn't said that he would cut back on the scope of interstate commerce allowed to support congressional action.
Well, I disagree, and I think if you look at Judge Roberts' not only background and views on these issues, but also the evasive answers given during the hearing, you will see that members of the Senate are deeply concerned about to what extent the court respects the power of the government to enact laws. And it's an issue that will, I'm sure, generate a vigorous amount of debate. Again, we don't know what he will decide. That's impossible to predict. He doesn't really know, but we do have a substantial record of perspectives on issues like that one that makes you wonder to what extent members of Congress feel that this is a judge who will be more like Scalia and Thomas, with a hostile attitude toward Congress often, or someone like a Breyer or even a Souter or even a Kennedy, who will on occasion respect the power of the government and find that they do have authority to pass some of the laws that are designed to protect the health, welfare, and safety of the public.
I can take another question from the audience if somebody has some.
Yes, this is primarily for Mr. Ogletree, but it was my impression that the Supreme Court is supposed to be sort of apolitical. It's supposed to stand above the fray and interpret the law. And it seems unfortunate that that the Senate seems to be using their political ideologies as part of the confirmation process. Now, you could rightly say that the president uses his ideology in nominating the candidate as well. I'd say that's unfortunate too. But the most unfortunate thing, it seems to me, is that we have the president's ideology conflicting with the Senate's ideologies, and we have this large debate over this when it's really supposed to be an apolitical issue, and we're supposed to just get a qualified person to interpret the laws.
You're absolutely right. The court should be apolitical, and we hope that it would be apolitical. But have you read Bush versus Gore from 2000? I say that quite seriously because when you read that decision, you will see a court that went to an extraordinary length to interfere with the right of the state of Florida to decide how to conduct elections and how to count votes. And indeed, not only did it go against its own precedent in ruling such as it did, but in that opinion, it went further and said, this opinion is only relevant for this case, and don't confuse us in terms of how we feel about certain rights of the states. And I think the court is generally apolitical, but when you read decisions, the justices have been very good and very artful at laying a foundation for issues that have some political consequences. Justice Scalia had to recuse himself from a case, you may remember, the case under God, because of statements he made publicly. He was challenged in the Cheney case because of having gone on a duck trip when he didn't recuse himself. But even more particularly, these are human beings. They are not naive about what's going on in society, and I wish the court were, in a sense, not apolitical, but at least conscious of the role that they're not just judges, but they're people too. And I say that because the problem that I see with the court today is not whether they're political or not, that we've lost the sense that there are many people qualified to be judges. When's the last time we had a Thurgood Marshall, someone who was threatened to be lynched, someone who was run out of town, who knew what it was like to be called a name? That's a sense of bringing not that to change your view, but having a sense about what it means to have a fair trial, what it means to have blacks struck from the jury when you're trying to serve, what it means to not be able to file bankruptcy if you can't pay the $25 filing fee. That sense of understanding the context of where you are doesn't change the way you decide the law, but it certainly means that people on the court should be aware of their surroundings. Justice Kennedy, in the Roper versus Simmons death penalty case for juveniles, looked at international norms and thought it was appropriate to not execute juveniles. Was he being political? No, he was growing, seeing that the world's view on executing juveniles had changed, so at this country's view. And I think that's a good thing that someone has grown and understands. It's not writing a new constitution, it's trying to interpret the current one with fidelity and with care, and not trying to make law, but trying to understand exactly what the law is based on what the circumstances dictate.
Well, at the outset, I should say that having been a Republican in academia in Boston, I know what it means to threaten to be lynched and to be run out of town. It's a perfectly understandable metaphor for me. I think the question is exactly right. The courts not only should be, but generally are apolitical. They do decide things in particular concrete settings, looking at the law and looking at the precedents, looking at what the Constitution says and trying to interpret and apply it. And that's the reason why when Professor Ogletree talks about Judge Roberts being evasive, I think he's using the wrong word. When a judge sitting before a group of politicians who want him to make promises says, I'm not going to tell you what my positions will be in advance. I'm not going to promise something to get confirmed. I'm not going to tell you how I will come out. I want to wait, see the briefs, hear the arguments, see the concrete setting, and make a decision when the case comes to me the way judges should. That's a judge doing exactly the right thing. That's a judge resisting the politicization of the courts. That's what Justice Ginsburg did when she sat before the Senate Judiciary Committee. It's what Judge Souter did. It's what Judge Breyer did. And it's what Judge Roberts did. And I think his answers were not evasive. They were the answers of someone who said, I'm not going to bargain with you. I'm not going to make pre-commitments. I'm going to wait and make decisions in the sort of settings that judges make decisions in, under the sort of constraints that guide judges, that limit their discretion, and that do together give us the rule of law.
Our satellite audience has been emailing in some excellent questions. This one will start with Professor Ogletree. Some Democrats on the Judiciary Committee have said that John Roberts' refusal to answer questions has left too many questions unanswered. And his supporters say that Justice Ginsburg refused to answer questions at her own confirmation hearing. Has Judge Roberts set a new standard for confirmation hearings that would allow nominees to refuse to answer any questions that might pose problems for their nomination?
I think the true answer is we don't know, because we don't know how the Senate will vote on Judge Roberts' nomination. It's clear that the minority leader, Harry Edwards from Nevada, who's a very moderate member of the Senate, has announced he's voting against him for the very reason that he didn't answer questions that were relevant. It's not how are you going to vote next year on this case coming up. It's here are decisions. What do you think about this decision and that decision? They've been decided. These questions weren't all designed to get him to say what he'd do in the future. The sense was, what is your judicial philosophy? And to say he doesn't have one, that's ridiculous. The first time you're asked a question as a law student, you'll have a philosophy, because you have a strong sense about whether it's right or wrong in that case. And that influences how you'll make decisions. And I suspect that Judge Roberts will be someone that has enormous comfort. He's argued many cases before the Supreme Court and been very successful. He's eminently prepared to do that. But it doesn't mean that a member of the Senate should not say, if you don't answer my questions satisfactorily, I owe a debt of burden to the citizens of my state. And I think you will see, both from the North and the South and the East and the West, a level of opposition, not enough to stop the nomination, a level of opposition to say we're concerned with Judge Roberts being Chief Justice with a lot at stake, and it's a wake-up call that the next nominee will have even more of a critical set of responses.
Mr. Cass?
I disagree with Professor Ogletree about what happened in the process and what the Senate was looking for. Quite clearly, I spent the week sitting in the hearings, listening to the questions, seeing what the senators were asking and how they were assessing the responses. They did want Judge Roberts to make commitments on positions before them. They wanted to get him down on paper, and when he wouldn't commit on certain things, when he said, that's a case that will come before me, they were frustrated. Now, of course, every judge who has gone for confirmation has said the same thing. Up until 1925, nobody ever appeared before the Senate Judiciary Committee, and the first person who did had to petition to appear to correct a misstatement about him. Until the 1950s, it was not common for people to appear, and when they began appearing before the Judiciary Committee, they didn't answer questions about their philosophy, about their positions, about how they would decide cases. Judge Roberts answered more questions more fully than any other nominee, but he did reserve the right to make decisions on concrete matters that would come before him in the particular context in which they arise. Anybody who's had to sit and decide a case and try to write it up afterwards knows how much difference it makes to see what the actual facts are and then to try to write up a rationale for a decision. Sometimes when you go to write it, your decision changes. And Judge Roberts understood that and reflected that in his testimony.
Mr. Cass, President Bush has said that he most admires Justices Clarence Thomas and Antonin Scalia, generally viewed as the most conservative on the Supreme Court. It has been widely speculated that he hopes to appoint other justices in their molds. Does Judge Roberts meet that test?
Well, I think what the President meant when he said he admires Justices Scalia and Thomas is that he views them as people who go back to the text and history of the Constitution. And I think Judge Roberts was signaling that he, too, will go back to the text and history of the Constitution, and those are the foundation stones for his decisions. Now, he didn't say he would stop there. He said over and over again that he also would give weight to precedent, that how much weight he would give depends on the precedent, depends on the quality of the precedent, it depends on how long-standing it is, on whether it's been undermined by changing circumstances, on whether it's been undermined by other decisions of the court, on whether it has a framework that is unworkable. He had a series of things he said he'd look to in trying to assess the way precedent would influence his decision. But he also signaled that clearly the two most important things for him are the text and history. Now, if you stop right there, you can't say that he is identical to Scalia or Thomas, even if we could make predictions, because those two justices disagree on how we should use text and history.
It's interesting. Dean Cass's answer, I'm sure it has, as we know in law school, gaps, ambiguities, and inconsistencies. Let me address some of them. For him to suggest that President Bush didn't get his wish by appointing Thomas, someone like Thomas and Scalia, is missing the point. Indeed, Thomas and Scalia are respected and known as conservative and consistently conservative jurists. And it goes beyond that. We have a long history with Scalia. It's over 20 years, nearly 20 years, and with Thomas, it's nearly 15 years. There's a body of decisions that they've made, dissents they've written, so there's no doubt about how they feel about the fundamental issues like affirmative action, which they're against, like Roe versus Wade, the right to privacy, which they are against, consistently against. And the reason it's important, it's not just a conservative, but the most conservative justice. President Bush didn't say, I want conservatives like Sandra Day O'Connor and Anthony Kennedy. Those are conservatives, because he knew he wanted something different, more stark, more clear, more absolutely unambiguous. And that's what he has. Someone who has a consistent record of conservative views on issues, someone who I still say will be confirmed, but we should not come back 5 or 10 or 15 or 20 or 30 years from now and say, gosh, we had no idea what he would do. We know, he knows, because it's clear that at the Supreme Court, Justices Scalia and Thomas are doing cartwheels now to say, my goodness, we don't have that questionable Rehnquist on issues. We've got somebody who's reliable and consistent, and my prayers go out to the Rehnquist family, but it's clear that Roberts is a smart, solid, critical vote. The president won the election, and he has the right to nominate whoever he wants to, and the Senate now has to decide whether or not to confirm it.
Mr. Ogletree, if most Democrats join Senator Harry Reid and decide to oppose John Roberts' confirmation, will that simply lead the Bush administration to choose a second nominee who the Democrats will like even less? Or alternately, would it influence the administration to pick someone more moderate and therefore avoid a fight?
Is that a law student's question?
I added to it a little bit.
Okay, all right. Let me say this. If the Democrats put up a fight and try to oppose Judge Roberts as Chief Justice, I don't think they will. That really is a truly hypothetical question. They won't. Not this Democratic Party, not this year, not in this Congress, and not against this nominee. It just won't happen. That's number one. If they did, hypothetically, President Bush would not nominate a more conservative, because we've had history with that. We had Haynesworth and Carswell, who were nominated by President Nixon, I believe, and who were both defeated. And I think Harry Blackmun may have been the replacement. We had Robert Bork, who was nominated and failed, and the president came back with Anthony Kennedy. And so I think the track record suggests that the president will try to find someone who can be confirmed, because the American people want the court to go forward. And I think everyone wants the courts to go forward, and I don't imagine any circumstance under which a more conservative candidate will be nominated for either the position of Chief Judge, if this were to fail, Chief Justice, or for an Associate Justice that comes up shortly after this is confirmed.
How do you do with stock market picks?
Very good.
I'm always happy to have somebody who's pretty good on predictions. I do know, by the way, that friends of Justice Thomas and Justice Scalia admire them, find them very fun guys. I've never seen either one do a cartwheel, though. So if they start doing that, we'll come back and talk about it. I don't think we know nearly as much about either how someone's going to vote, what the issues coming before the judges are that they will be voting on, or what we can expect from them on the basis of what we see in the record at their confirmation. Otherwise, the predictions that Now and other organizations were making about Justices Powell and Blackmun and Stevens and Souter and Kennedy would have been right instead of wrong. They have a consistent track record of guessing wrong about what these judges will do on the issues they identify. As to what the White House will do if there is a no vote of a lot of Democrats, first of all, the no vote won't prevent confirmation because there aren't enough no votes. And secondly, I don't think we can say what the White House will do. I think that the president has indicated right along he's going to make each selection on the merits independent of anything else happening. And whether his popularity is going up or down, whether he's doing things you like or dislike, he seems to be a president that sticks pretty closely to what he said he's going to do. He said that's how he's going to go about making his selections. I take him at his word.
Can you let Ron and I ask each other questions? You've got a lot of questions there. Ron, let me just ask you this. If this nominee had been Alberto Gonzalez,
he'd speak Spanish much better than Judge Roberts.
Indeed. But what's your sense? There's already been a lot of conservatives opposed to the idea of Gonzalez because they say he's not solid on issues like Roe versus Wade or affirmative action. Knowing what you know about Alberto Gonzalez, is he an ideal candidate for the Supreme Court?
Well, I think that it's very difficult, again, to try to make these sort of predictions about what people will do. Judge Gonzalez has a long track record. He was a judge on the Supreme Court of Texas. He has been the Attorney General. I think we do not know how he would decide many different issues. People tend to read tea leaves, and they often read tea leaves wrong. Anybody who's looked in the bottom of a teacup knows how difficult reading tea leaves happens to be. But while we're asking questions, I noticed that when you were listing the things that it's important that we have the right judges on the court, because this is what the courts do, you mentioned that they've protected things like women's suffrage. And aren't those the sorts of things we have the amendment process for? Isn't that how we got women's suffrage?
Indeed, we need a Supreme Court that will support it as well. I mean, they're not exclusive. And the whole idea is to have a government that works together, all three branches. And my fear is that when you ignore the court, you have the dangerous precedents that brought us into the 19th and 20th century. And we've come a long way. It's a different country. It's a different group of people. It's a different texture to what we have now. And no one can say that the law is settled, the Constitution is unclear, or clear on every conceivable issue. And I just want to make sure that we understand that we are not the America that we were 50 years ago, that we were 100 years ago. And anyone who's appointed judges who will decide the future of America's laws should be aware of whether or not someone would, in their view, take it forward or take it back. It's a simple question to ask.
I think the one thing I would say, and I do think we could use up the rest of the time this way, Emily.
You have 5 minutes.
The one thing I would say is I think it's important not to be looking at the court as a court that will do what we want it to do on policy issues. We don't want to be looking for judges that we think will do the things that we would say would be good policy. We have electoral processes for that. We have elections for that. We have presidential elections. We have elections for the legislature. We want a court that will enforce the laws as written, that will enforce the Constitution. Our protection against tyranny is to have courts that will obey the laws that we have rather than try to figure out what the right values are for the future. And I worry about us reading too much into what it is we ask judges to do. It makes our guesses wrong, but it also makes the courts more political and less legal.
And I agree with you. I don't think judges or justices should be involved in making policy at all. But they do need to interpret, what do we mean by equal protection? What does due process mean? What does the Commerce Clause mean? What do we mean by federalism? Those are questions that seem to have obvious answers, but 4 justices feel one way and 4 feel another way. And that's one of the challenges here. How do we have people reading the same clause of the Constitution or the Bill of Rights or the amendments to the Constitution and coming out with radically different interpretations of what it means? So if they're not political, someone who says that affirmative action is illegal and someone who says it's legal, that has something to do with their political and ideological makeup, because they're reading the very same language, the same tenets of the Constitution, and coming to diametrically different conclusions.
Okay, let me ask one more question, and if you don't mind, maybe we'll give you each 2 minutes to answer it. Mr. Cass, if a judge's positions on policy issues should not be taken into account in choosing him for a court, as you seem to suggest, why hasn't President Bush nominated any appeals court judges who are openly pro-choice?
Well, I think that the president always is looking to put people on the court he thinks will decide cases according to the way he reads the Constitution and history of the country. Every president has looked to do that, and historically the Senate has said that is what the president's right is. The president gets elected, runs for office on the basis that there are certain things he stands for, and that president gets to nominate, and with the advice and consent of the Senate, he gets to appoint judges who will decide cases in the manner that he thinks is the right way. Now, having said that, it doesn't mean the president ever sits there and says, how do you feel about this? How do you feel about that? My history in going through the confirmation process is that people always assume you've given guarantees on things the White House never, ever asks you about. And my sense is the president is very sensitive to the role that he has in picking people. He's to make the assessment of how they'll approach things, not ask them for commitments on specific outcomes of particular types of decision.
My response is that Ron's exactly right. The president has an ideological litmus test, but he doesn't come into the room naive. That is that when you find these candidates, they have been vetted. You know what they've said. You know what they believe. And occasionally they slip up. And one who slipped up, President Bush, was Justice David Souter, because they thought they had an ideal choice. Indeed, I was one of those people who was critical of Souter as a stealth candidate with no record, and I didn't think when I was expressing my opposition that I would be before the Supreme Court 3 months later and arguing before him. I didn't realize either when I argued that Supreme Court case, the death penalty case out of Georgia, Ford versus Georgia, that as Marshall gave me support and Rehnquist and O'Connor asked tough questions, Souter just sort of stared at me during the entire argument. But when it was decided, Justice Souter, come to learn, wrote the opinion. It was a unanimous opinion reversing the death conviction of an African American in a Georgia criminal case. And the press asked me what I think about Souter. I said he's the most balanced, fair, insightful, brilliant, and that's part of the process. No one quite knows. There should be no litmus test. And what we have seen is that justices have grown over time. Judge Roberts has enormous possibility of growing as the Chief Justice of the Supreme Court. And I'm hopeful, I know he will be confirmed, I'm hopeful that he will learn from these hearings that America has changed, and he's not the person he was sitting in that class at Harvard in the 1970s, or sitting in a government office in the 1980s, or sitting in the Solicitor General's office in the 1990s. He's a different person at a different time, and that he'll appreciate, as Justice Kennedy has and Justice O'Connor did, that America is a different place. You can still respect the Constitution, believe in the Constitution, be very conservative, and yet recognize that America is a different place. Values have changed, and we need to be in the 21st century, not in prior centuries, and trying to make sure that we address the issues that come before us.
All right, we're going to take 2 more questions from students in the audience at the mic.
Throughout this entire process, Judge Roberts has adamantly refused to share his beliefs about how he would vote on certain issues, yet the senators keep asking him, how are you going to vote on this certain issue? How do you think we could go about the confirmation process and find out the qualifications we want this judge to embody without asking, like, what kind of questions should we be asking?
Well, I'm happy to go first on that one. I think that you're not going to get a judge who's thoughtful about his or her job to tell you how they're going to come out on particular policies or doctrines or cases that might come up before them. And the senators who are probing for that are looking for the wrong thing. What they ought to be doing is trying to see how the judge thinks about the law, how the judge thinks about precedent. And there were some exchanges this past week with Judge Roberts about that. There were some exchanges about precedent where he explained what role precedent plays in his thinking, how precedents differ, how they change over time, what builds up or undermines a precedent. Those sorts of exchanges can give the senators some sense of how the judge thinks about the law. If you view the courts as political institutions and not legal institutions, if you want political commitments from the judges, you have the wrong conceptions of the courts and the process. One thing I think it's important to point out, there are 90 million legal actions in the United States every year, which is why we have so many law students. It's a wonderful thing. We only have about 80 to 100 decisions in the Supreme Court. It's a tiny, tiny fraction of the overall legal system, and we tend to exaggerate the small number of those cases that have splits among the justices. The most common outcome at the Supreme Court, as in Professor Ogletree's case, is unanimity, which can be brought about by the brilliance of the argument presented, or by the fact that the case simply fits that way in the law. But it is a few cases that we tend to focus on that are hard to decide, and we tend to impute politics into them. I think we make a big mistake doing that.
Well, let me just first, that was an excellent question, and let me tell you why. When you talk about what the senators should do, I don't think that they have, in fact, I disagree in the sense that they affirmatively have an obligation to probe the person who's going to be appointed to the Supreme Court. Why? They run for office, they have no guarantee of incumbency. They have no guarantee to be reelected. They have to run. The president has no guarantee that he could appoint someone in 2009 because he can't serve again. The Supreme Court is one of the few institutions in our nation's history that gives a person a lifetime appointment, and of course tenured law professors, right? And it's a very serious determination. They're not deciding about John Roberts for today or this term, it's for the lifetime, and they need to have a sense of how he will decide. Some of what we saw this past week, Ron may describe it differently, but some of it was a charade, because you'll see these senators asking these questions. They couldn't answer them themselves. The aides do a great job of writing these questions, but you know exactly, they have no idea what they're talking about. And they'll ask this question, Judge, I understand that you were an honors member of the ACLU, and I don't know what that means in terms of your judicial philosophy. With all due respect, Senator, I was an honors graduate at UCLA. Well, what's the difference, right? So they can't even appreciate the complexity of what they're doing, and it looks like a charade just to make the record. So I don't know that they've probed nearly as much as they should. They've done their job. Roberts has answered the question to the satisfaction of enough people to get confirmed. There is no smoking gun out there, so I suspect that we've seen our democracy work. If people watch it, what's interesting? I bet we had less viewership at this confirmation hearing than we've had in many. Katrina certainly had an impact on that, but you think about Clarence Thomas, you think about these other hearings. This was not contested because we knew in advance that there weren't a lot of areas of serious contention where the gang of 14 senators would see Roberts as outside the bounds of acceptability. Conservative, predictable, yes. Extreme, many believe no. And therefore, this is a very different hearing, and Ron probably stayed awake through most of it. I can tell you that some people slept through parts of it because it was that predictable in terms of what he would say, what they'd ask, and what would be the consequences.
I do want to end on one note of agreement, and that is, I've been to UCLA. There is no difference between that and the ACLU.
I think we have one more question from the audience.
Well, here's what we're going to do. Excuse me. I think we're going to end the formal part of this program, and we can continue with this discussion, but I just want to thank everyone who has tuned in from your law school campus. I want to thank a variety of organizations that helped make today possible: the American Constitution Society, the National Lawyers Guild, the Federal Society, the Committee for Justice, Georgetown Law Democrats, Hispanic Bar Association Law Division, and Equal Justice Works. And I think a round of our applause for Charles Ogletree and Ron Cass and Emily Bazelon. And I hope that today's discussion just sparks more debate at your campuses about John Roberts and the next nominee, and there will be a next nominee in the future of the Supreme Court. I also hope you will remain active participants with us at the Alliance for Justice, with our Student Action Campaign. Campuses are the places where political movements build and grow, and we look forward to working with all of you. Thank you very much, Emily. When do we continue? Do you want to continue?
Sure. Okay. Let's continue a little bit with the next question, I think. And anyone who wants to stay is welcome, and anyone who needs to leave is welcome to leave.
Well, does that include us?
Hard questions
you guys have to stay, sorry.
They're going to double our pay for this.
Well, I appreciate you being willing to stick around. What I wanted to ask you, especially Dean Cass, as you were talking again and again about it's important for a prospective justice not to go into detail about matters that will come before him. What about the other 7? We already know where those 7 justices stand on so many important issues that probably will come before the court again. And is it wrong to potential litigants in front of the court to know where those 7 justices stand, but it's better for them not to know where the new justice will stand?
That's an important question. It's one that was pressed against against Judge Roberts' spot demotion over and over again. The people on the court have made decisions in particular cases. They've made them in a context where they had no political pressure on them. They're there, as Professor Ogletree said, for life. They're seeing the briefs, they're reading them, they're listening to the arguments, they're thinking about how a particular decision in this case on this set of facts affects the law, how it fits with precedent, how it fits with the constitutional text and history. When you're sitting in the Senate hearing room and somebody is saying, Judge, do you believe there's a general right of privacy? Do you believe that we ought to have racial preferences, that we ought not to have racial preferences, that benign preferences are different from preferences that are growing out of racial hatred? Any question the senators are asking, they are asking not in a very particular context, not in a way that you can sit back, reflect on how it affects things in the particular setting. They're asking for a commitment as part of a bargain. You answer it the way I like, I'll vote for you. You don't, I'll vote against you. And that is exactly what the Constitution was designed to insulate judges against them. That's the reason why it took so long to ever get a judge sitting up before the committee answering any question about judicial philosophy or positions or views.
And the real answer is this. I wish this generation of law students would have the opportunity to go back and read the full transcript of Judge Robert Bork's confirmation hearings. I think therein lies the answer, because Judge Bork, when he was nominated, had some views, not just what he had written. That didn't really destroy him, but his answers were such that he tried to answer the questions in the way he believed, and that led some members of the Senate Judiciary Committee and members of the Senate ultimately to determine that he didn't believe in basic values that had been upheld by earlier courts. Now, he was honest, but it cost him. Right? I mean, there was a sense he was honest. He expressed his views and tried to nuance it, but it cost him. Judge Bork had been on the D.C. Circuit, I don't know for how long. I don't think he'd ever had one of his opinions reversed by the Supreme Court. So, I mean, clearly was a brilliant, is a brilliant man, but was a brilliant judge. But that hearing for students of the law is a classic example, unlike the Thomas hearing, which focused on other issues, a classic example of how these debates occur and how candidates, I think Bork thought, and maybe he was right, that he was smarter than the collective brilliance of all the members of the Senate Judiciary Committee, but that might have cost him because he didn't have a vote. And ultimately they had to decide whether or not he was acceptable. But it's a classic hearing, and we knew where he stood, and that's why the substantial number of people who rejected him did so.
Well, I was actually on the faculty at Boston at the time that happened and had an office here at Georgetown visiting here. I met Father Drinan in the faculty lounge every day to discuss how the Bork hearings were going. Needless to say, he and I had somewhat different views on how they were going. But you're absolutely right, Charles, that none of the questions dealt with anything he decided as a judge.
Right.
He'd had about 6 years of judging, and nothing that he'd done as a judge raised any flags for anyone. So all of the focus was on Professor Bork, not Judge Bork. It was on his writings, his 1971 Indiana Law Journal article. And the insight that I got to the hearings was when one person who watched us, watched Father Drinan and me in the lounge every day trying to persuade each other how the hearings were going, said, neither one of you have the right approach to this. You're both listening to the hearings. You're talking about the substance. What you both need to do is to go back to your office, look at the TV, turn the sound down. Mm-hmm. And if you can't quite make out what they're saying, you can only hear the tone of voice and see the facial expression. Then you'll know how the rest of America is experiencing these hearings. And it was a very powerful experiment and not one that worked out very favorably for the judge.
All right, one more question?
Yes, please. During his tenure here on the appellate court, one of his rulings was on the French fry case. I would be interested in both of your interpretation. What does his ruling, what do you take away from that? What do you extrapolate?
Well, I don't think, those of you who don't know this, it's the Hedgepeth case in which a young woman who was eating a French fry was prosecuted. And the prosecution was upheld by a liberal Democrat judge who was a Clinton appointee who said, I find this abhorrent, but the law compels me. The law as written says she's guilty of a violation. I don't have a choice. I don't like it. It went up to the Court of Appeals, and unanimously, the Court of Appeals said, we agree with the judge below. We don't like this either. The law is clear in this context. And often that's exactly what judges wind up doing. They say, it doesn't matter how I feel about this. It doesn't matter what my views are. It doesn't matter that I would have written the law differently. The law is clear. We don't have a choice in the outcome. We can only hope that the political branches go back and change the law.
I think that's right, because if you look at that opinion in particular, Judge Roberts must have imagined at some point that he might have a future as a judge on a higher court, because even in that opinion, he expressed clear sympathy for the young lady, but said his hands were tied. You have to abide by the law. And I'm glad he did both, because that opinion could have been written simply on the statute without a consideration of the person involved. Doesn't mean he'd ever change his vote, but that was an inkling for me that he at least is aware of what's going on. There's a sense that he empathized with the circumstances, and perhaps in the right case and the right circumstances, I can imagine him deciding a case for someone that might surprise those who believe that he's going to always be particularly conservative. He, like Judge Kennedy and O'Connor, hopefully will be independent and therefore decide the cases as he sees them, which may mean that the doctrines that this court has upheld with a majority of conservatives, 7 appointed by Republicans, have upheld. And if he is consistent with what this court has done, I could not be more pleased that Bush appointee of a conservative jurist upholds what the 7 members of the Supreme Court now find acceptable, even though some of them would disagree.
I thought we were going to get the tough question, which is what happened to the rest of the French fries.
Right.
Thanks so much to both of you for sticking with us for this little extra session. And thanks so much to Nan for having all of us and to the law school for hosting this event. And now Jordan is going to tell us where we can go next.
Yeah, on behalf of all the students, thanks again for all of you coming to the debate and the encore. There'll be a reception just right outside, up the stairs there, appetizers, drinks, and non-alcoholic beverages. Thanks.
Thank you, Charles. Hey, Charles, enjoyed it. Let's hear it.
So, you guys still have you kept your house in Boston?
No, we're gone. Well, let me give you a...
Really? I heard that, but no teaching?